Walcott v. Garland. It was published on December 22nd. And this one is just absurdly complicated. I'm not going to get into it, but it's essentially about drug trafficking and whether it's a crime involving moral turpitude. And the case goes all through the Ninth Circuit's prior precedent, and the Ninth Circuit is distinguishing its precedent. And it is kind of fact-specific based on the Arizona statute at issue. But at the end of the day, it did hold that this specific Arizona transport statute of less than 2 pounds of marijuana is not a CIMT, in part because less than 2 pounds has been deemed to mean as little as 3 joints. And so, it's a wide range, and you don't know if it's the 3 joints or the 2 pounds. And so it can't be turpitudinous. It's a complicated analysis, as it always is. Sure, no, it's about drug trafficking, and it's very complicated. It's about a specific Arizona statute, right? And it held that this specific Arizona statute is not a CIMT because it's transporting of 2 pounds or less of marijuana, and the way Arizona prosecutes it, it could be 2 or 3 joints, all the way up to 2 pounds. And so, under the categorical approach, you don't know whether it's 2 pounds or 2 joints, and so that was one of the reasons it was held not to be a CIMT. And very fact specific, and it's a primer on making these categorical approach arguments. But what I like,
it's really important right there, because I thought it's up to the petitioner or the applicant to be able to prove that. I didn't realize they could argue that. So that's going to be used widely, these kind of cases.
It depends. It depends. It's the realistic probability test, and it depends how it's being applied in all the circuits. And this is a whole podcast episode for another day, and I think it needs to go back to the Supreme Court. But even if we're talking about the realistic probability test, the applicant did prove it here. You don't have to prove it with your own case. It's with your own case or other cases. And here, Mr. Walcott, or Miss Walcott, I believe, found Arizona cases where it prosecutes 2 or 3 joints. And so that is sufficient to meet the realistic probability test. But very complicated issue. I believe that if the statute clearly is overbroad, that the realistic probability test has no role to play. And the Supreme Court in Duenas-Alvarez, that is what they said there, but this is a whole nother conversation. But while I like Walcott so much is because at the end of it, the Ninth Circuit says, just to paraphrase, essentially, societal attitudes towards marijuana are changing. And so because of that, the CIMT definition is changing. And in part because of that, transporting less than 2 pounds of marijuana is not a CIMT. And again, it's specific because it could have criminalized 2 or 3 joints. But the greater point is good. And the court talks about Lawrence v. Texas and how sodomy used to be a CIMT. And then, when case law changes, so too does the law. And the Ninth Circuit is poised to change the CIMT definition vis-a-vis marijuana because society is changing about marijuana.
That's a big deal. The case statements are a big deal. Wow.
Yeah. So those are the 4 cases, the 4 case rundown in 20 minutes.
We did excellent job. Kept my attention going through all of them. Perfectly prepared. Sometimes it's like, this is getting too complicated for me. So I'll just say it for our viewers who need to know this stuff, but this is beyond me. But all of them were really interesting.